But today's talk will actually focus on employment law and the director's duties, which will affect every single one of us, which is really very pleasing. You obviously know that Kennedy is a very well-known legal firm within the insurance region, and they've also got regional offices, and they don't only deal with insurance disputes, but have a great deal of expertise in corporate and public sector, thank you. I'll leave it in writing. Sector litigation, so that's really pleasing. So what I'm going to do is I'm going to sit down, be quiet, and hand over to Chris and let him share the particular meeting.
Hi, thank you, Peter. We're very pleased to be given the opportunity to present to you today and look forward to working with the MGAA more closely in the future and yourselves as its members. As an international law firm with offices across the world, we remain focused on the insurance sector and providing straightforward, pragmatic advice to our clients. While today's talk focuses on employment law and directors and officers' duties, as a firm we specialise in advice across a broad range of topics and areas, including, but not limited to, the variety shown on that list there. Construction insurance being my own area of expertise. We also have a global network of Kennedy's offices, which allow us to provide local advice in jurisdictions right across the globe. To the extent to which anybody has any queries regarding areas outside of today's expertise or the stuff we discuss as a panel, please do feel to grab any one of us at the end. We're happy to answer those or direct you to the appropriate person at Kennedy's who can assist you with that. So turning to today's speakers, Matthew is a partner in our specialist employment team. He focuses on helping employers and their insurers across the full spectrum of employment law. That includes day-to-day HR issues, which we'll cover today, business restructuring projects, contracts and policies, as well as defending claims. Matthew will be taking you through the first part of today's session. Jenny is an insurance partner specialising in financial lines work, focusing on financial institutions, directors and officers, crime and regulatory proceedings. She regularly advises on cover and in the areas and defends financial and commercial entities, directors and officers and other professionals in civil and regulatory matters. Finally, assisting Jenny today is Alex. He's one of our rising stars of the insurance team and who specialises in claims against financial institutions, directors and officers, as well as energy disputes and property damage claims. Turning to today, Richard Branson famously said, "Clients do not come first. Employees come first. If you take care of your employees, they will take care of your clients." With that in mind, and with a view to helping you inspire and retain talent within your organisations, Matthew, Jenny and Alex will take you through the pitfalls that being leaders in your organisations give rise to, along with some tips as to how to limit your own exposures. Matthew.
Thanks very much, Chris. Well, good afternoon, everyone. It's a pleasure to spend a short amount of time this afternoon discussing some key HR and employment law issues that you may face as employers. Employment law is a vast topic. I've actually brought along a prop stroke a cure for insomnia, depending on which way you look at it. This is called the Green Book. This is the Bible of employment law legislation, which we practitioners use. Very, very tiny print, microscopically thin paper. This book gets republished every year, and it grows every year. If anyone wants to borrow that, you're more than welcome. I can't go into every area of importance today, and I can't cover the topics that we are looking at today in any great detail. But what I have done is select a few topics which I hope will be of interest and common issues that arise during the course of any employment of your employees that you may be dealing with at any one time. That said, for those of you who haven't flicked through all of the printed copies of the slides, you may be wondering why on earth there is a photo on the slide of a man chopping down a tree with an axe. I haven't gone mad. All will be revealed in a few slides' time. So, first topic. Obviously, at the start of any employment relationship, it's vital to get into place good employment contracts so that there is no ambiguity, there is no uncertainty as to what you've agreed with your staff. Typical things you'll obviously expect to see in an employment contract, things like pay, importantly, holiday entitlement, sickness, hours, location of work, particular duties, and so on. But not all of those obvious things. There are other things which you might not give a lot of thought to at the outset of an employment relationship, which are well worth thinking about and dealing with from the start. Peter and I were chatting just before the session started, and Peter made the comment in the context of a different contract that you don't often think, or people often don't think about what happens at the end of a contract. And that's equally true in an employment contract. So you want to consider things like how much notice do you want to be obliged to give an employee? How much notice do you want them to have to give you if they want to leave? Are you worried that the employee might leave and take important clients with them? Are they going to follow that particular employee? They are all things which you can tackle early on when you're forming the contract, but can be quite difficult to revisit later on. Note also that in one of the bits of legislation tucked away in that book, the Employment Rights Act 1996, there is actually a legal obligation on an employer to provide a certain amount of information in writing about the key terms of employment, and that has to be provided within the first month of employment. So there is that legal obligation in the legislation, as well as it being in your best interest to have an employment contract in place. Contract's only perhaps one side of the story, though. There's also the need to have policies which supplement the contract. Again, all sorts of different policies you might have as an employer, but particularly important ones are to deal with discipline. If you've got a misbehaving or a poorly performing employee, have you got a process in place that deals with that? Grievance, equally, you may have an unhappy employee from time to time. What are you going to do to follow a process to let that grievance be heard? Health and safety, are there any particular obligations that you need to make your employees aware of, or have them follow particular rules? IT and IT security, that's another important area, increasingly so. In particular, making sure that employees know what they can and more often cannot do in terms of IT use, emails, internet access, and so on. Increasingly also social media. You know, we're seeing an increasing number of claims where employees are tweeting stuff, putting stuff on Facebook, which is having an adverse impact upon their employer. So having an effective policy in place which tackles that at the outset is a good thing. Anti-bribery, again, that's important. There's been specific legislation in place since 2010 which obliges us as employers to have procedures in place to prevent employees doing anything that might be a bribe. Incidentally, this is necessarily a whistle-stop tour, but we will be around at the end for questions, so if there are any points that you want to raise, please do grab me. Okay, the next key topic that I just wanted to touch upon was discipline and performance. From time to time you will have a misbehaving employee, a poorly performing employee. And there are some key issues which the employment case law over the years has established as to a fair way of tackling those issues. So if we look at performance initially, a key tenet of the law to emerge is that an employer should investigate the employee's apparent failings. So if you've got an employee who's badly performing, why is that? Is it a lack of training? Is it something going on at home? Are they just not very good at the job? But before you take action, you'll be expected as an employer to make a reasonable effort to investigate what's causing the poor performance. Warnings are also important. Unless you've got something which is, gross incompetence. I mean, the example that the case law always gives is of the airline pilot who forgets to put the wheels down as he's coming into land. Unless it's something really very serious, then normally you would expect to be giving the employee a warning before moving ultimately on to parting company. Combined with the warning is the importance of a reasonable opportunity to improve. We're expected to not only warn the employee that their performance isn't up to scratch, but to give them a clear idea as to what they need to do to improve, as well as a reasonable period of time to do it. And what that will be will depend on the circumstances in each case and the particular performance failing. But once that's in place, you've warned the employee, you've given them a chance to improve, you'll then need to monitor the progress against the requirements and take further action if necessary, if there is no satisfactory improvement. Discipline is very similar to managing poor performance. Again, it involves a certain level of investigation. There's been an allegation of misconduct of some sort, whatever it might be, drunkenness, fighting, IT abuse, harassment of another employee, all sorts of things which might happen. First port of call is to carry out a reasonable investigation. Are there any witnesses? Are there any documents which are relevant, and so on? And then ultimately, depending on the findings of that, you'll want to consider what the next step is. If it's something fairly low level, then in many cases an informal response is appropriate. It might just be something that requires a sensible word on the side and no formal action. But there will of course be cases that you may come across that need some more formal action than that. Maybe a first warning, maybe a final warning, ultimately dismissal. But obviously all of those steps need to be taken with some care. And going back to the previous slide, the importance of having a well-documented disciplinary procedure will help you enormously. The other thing that will help you as employers enormously is the ACAS code. To give it its full title, the ACAS Code of Practice on Handling Disciplinary and Grievance Procedures. It's a bit of a mouthful, but ACAS are basically the intermediary neutral body that is funded by the state to help employers and employees in a variety of employment situations. It could be individual tribunal claims, it could be mediating in industrial disputes that you'll read about on the news. But one of the things that they are tasked with doing is publishing best practice guides, codes of practice. And the Code of Practice on Discipline and Grievance is one of their keystone documents. Employment tribunals certainly take it into account. They're obliged to take it into account when assessing how well or not an employer has dealt with a disciplinary or a performance issue. It's a very readable document though. I do recommend it. It just gives very basic, understandable guidance as to how to handle a misconduct or a poor performance issue. And if you read that document, you won't go far wrong in dealing with either of those situations. I've put the ACAS link up there. You'll see there's a documents section, and you can find the relevant document. Okay, moving on. Another key issue that you may come across from time to time is ill health absence. You may find yourself with a member of staff who's away due to health reasons. And I guess broadly there could be two types of absence you might be dealing with. There's the employee who's off for short-term, intermittent periods, the odd flu here, the stomach bug and so on, but it might get to a stage where it's actually a bit more absence than you can reasonably tolerate. So what do you do about that? Well, again, all fairly commonsensical stuff, but for each instance of absence you'll want to investigate it, i.e. speak to the employee as to what the issue is and whether it's genuine. Insist on GP certification, called fit notes now, that get evidence from the GP that certifies the absence. And develop policies and procedures which deal with how you manage people whose absence is unacceptable. So many employers will have a policy which will say, after so many days absence within such and such a period of time, you will trigger a warning. And then you'll be monitored, and if there is no further improvement, a second warning and so on. So there is a clear path towards hopefully improvement, but if not improvement, then perhaps parting company. Long-term ill health absences, so people who are away for an extended period of time with a particular condition, needs a different set of considerations. And the points I put on the slide there really encapsulate what the case law over the years has established that an employer acting reasonably needs to do. First of all, there is an issue to establish what really is going on medically with the employee. You may need a report from the employee's GP to tell you about the condition, the prognosis, their likely return to work. You may need a specialist in certain situations. But you're not expected to be medical experts, but you are expected to take appropriate advice. Consultation with the employee is another key point. The employee will have their own views as to their ability to work, their likely length of absence and so on. So again, you'll be expected to take the employee's account into the equation when you make a decision. Ultimately, you're asking yourselves, so is a return to work likely within a reasonable period of time? And if not, is there anything else that might be offered to the employee? Can they be moved to another role? Is there anything that can be done to prevent you ultimately having to part company? So they're the key issues from an unfair dismissal perspective, which I'll come on to. But note there's a particular issue here about the potential for dealing with disabled employees. Now, I've put a reference there to the Equality Act 2010, and forgive me if this is stuff that you're familiar with, but the Equality Act is the piece of legislation which deals with the prohibition on discrimination in relation to various characteristics, so age, race, religion, sex, maternity, and so on. One of the areas of discrimination is disability discrimination, and it's something that can catch employers out from time to time, because in order to be disabled for the purposes of the Equality Act, the employee only has to satisfy a definition which has a fairly low threshold. So it's not the same assessment that's used to assess disability benefits by the state. It's a separate definition. You have to have a physical or a mental impairment which has a long-term and substantial effect on day-to-day activities. But the key there is that substantial is defined as more than minor or trivial. So you can find sometimes with employees, particularly with things like back conditions and stuff like that, that whilst they may not be on disability benefits, they can actually be disabled for the purposes of this legislation. And what that means, the significance of that, is that the employer then becomes under a much greater duty to see what it can do to make adjustments to allow the employee back to work. So adjustments could be things like changing their hours, changing their location of work, ultimately providing them with equipment, or ultimately moving them to a vacant job, which they are able to do. And that thought process needs to be gone through before you decide what to do with an employee who is off on long-term sick. So just as a general point, if you've got an employee off on long-term sick, the question that you should be asking is, well, might they be disabled? And if so, what duties does that place on me? What do I need to think about before I start making decisions about what I do with them? Grievances, very briefly. I talked about the written employment contract at the outset. Occasionally you may have employees who've got a problem about something. A complaint might be about the way they've been treated, might be about how another member of staff has treated them, whatever it may be. There is an implied obligation on all employers to give some reasonable opportunity for that to be heard. I mentioned the ACAS code earlier. There's also a positive obligation on that document on all employers to go through a process in order to let that grievance be heard. And if you don't do that, if you ignore it, there is a risk that the employee could take that as a ground to leave and say that they've been constructively dismissed. And I've put up on the slide there the basic process that the ACAS code at least expects an employer to follow. It's all very straightforward stuff, having a meeting once you've got a written complaint and giving a right of appeal if the grievance isn't upheld. Very briefly, family-friendly rights. Again, this is really just a heads up that there are a number of what might be referred to as family-friendly rights in the legislation, i.e. particular rights to either time off and or pay in connection with family-related issues. So I've put the main ones up there. So maternity leave, shared parental leave, where the mother and the father can effectively share the maternity leave period. Similarly, adoption leave, paternity leave, the right to take emergency time off to deal with things affecting dependents, flexible working requests. You may have employees requesting to work flexibly, to work reduced hours or different times of the day, whatever it may be. There's specific protection given to part-time workers. They shouldn't be treated less favourably compared to equivalent full-time workers. And similarly, fixed-term employees, people who are employed for a fixed period of time, have certain rights as well. So I'm not going to go into any of those in detail, you'll be pleased to hear, but it's just really a heads up to be aware that these rights exist, that there is legislation out there, and whilst it's, you'll say I'm bound to say it, but it really does merit to take early advice, and you can often spend a lot more by not taking early advice than you do by doing so. Just one example from real life. A client a few years ago, managing director of a business, employee comes back from work from maternity leave, requests to go part-time, without a moment's thought, blasts out an email, and I quote, "This will never work. Tell her no, full stop." It's quite hard to row back from that and show that you've actually given it some proper thought and come up with good reasons as to why that request couldn't be granted. Okay, just coming to the end now. A quick word about employment tribunals. I don't know how familiar or not any of you are about the employment tribunal system, but just to make the point that most employment claims, if you're ever in the unfortunate position of being on the receiving end, will be heard in the employment tribunal rather than the civil courts. There can be civil court claims for contractual matters, but most of the rights that we've been talking about are in the employment tribunal, which is a separate jurisdiction. Common tribunal claims, unfair dismissal, i.e. an employee who's been dismissed can challenge the fairness of their dismissal, hence the relevance of going through the steps that we were looking at earlier. Discrimination is discussed. Whistleblowing, people who say that they've made a complaint which is protected in law and then they've been dismissed or subjected to detriment because of it. Deductions in pay, redundancy payments, all sorts of things. The system's gone through some changes over the last few years. So it used to be completely free. The employee could just lodge their claim and it would eventually go to a hearing. Now they have to pay a fee. They have to pay the fee in 2 stages, a fee at the outset, and then if it goes all the way to a hearing, a fuller fee. So the total fees can now be up to £1,200, which is not a small amount of money, particularly if you've lost your job and you're pursuing some sort of unfair dismissal claim. So the result of that has been a reduction in the number of tribunal claims over the years, but it's starting to sort of creep up again now as everyone gets used to the new system. The costs regime is a bit different to the civil courts. Costs do not automatically follow the event, so the loser doesn't necessarily pay the winner's costs. There are some exceptions to that, but by and large, even if you successfully defend an employment tribunal claim against your business, the likelihood is you'll have to meet your own costs, unless you've obviously got an EPL type policy which covers you. There are quite short time limits in employment tribunal litigation, so the employee typically has just under 3 months from whatever they're complaining about to get their claim in. Again, there are some exceptions to that, but 3 months is the general rule. And the employer then only has 28 days to get their defence in. So, again, if you are in the unfortunate position where you have that claim form land on your doormat, it's really important to start taking action quickly. Final word about tribunals. I keep mentioning ACAS, but they're relevant again to this. There's now an obligation before any employee goes to tribunal to go to ACAS first and try and see if a settlement can be reached. That's my timer for my 20 minutes, and it's telling me my time is obviously up, so I shall be very brief. There is an obligation on an employee who wants to go to an employment tribunal to first go to ACAS and say, look, I've got this potential claim against my ex-employer or my current employer. This is what it's all about. And ACAS will then go to the employer. They'll go to you. They'll say, this is what the employer is saying. Is there an opportunity here to reach a settlement to avoid going to litigation? If not, then ACAS will give the employee a reference number, and then they're free to go after the tribunal. So there is an opportunity before any claim reaches you to have that settlement discussion. Okay, well, finally, the axe photo, you may have seen it on the side already, but in preparing the talk, I was looking at what inspiration I might be able to take from newsworthy events of late, and obviously the current US president and his Twitter account have been featuring in the news quite a lot, so I thought I'd look back through the annals of history to see if there are any other interesting quotes by former US politicians that might be relevant, and I came across these 2 nuggets. So Abraham Lincoln, give me 6 hours to chop down a tree and I will spend the first 4 sharpening the axe. And then Benjamin Franklin, an ounce of prevention is worth a pound of cure. By failing to prepare, you are preparing to fail. They didn't have Twitter accounts in those days, but those concepts of preparation is better than cure really does encapsulate how most employment situations should be dealt with. The more you invest at the outset in terms of the documentation and the process that you follow, so much better the outcome will be. That's all from me. 2 minutes overdue, and I think Alex is next. Thanks, everyone.
Good afternoon, everyone. Thank you to Chris for my introduction. Thank you to Matt for taking us through the pitfalls of employment law. I'm going to give you a brief overview of the main duties and responsibilities that are facing someone who acts as a manager, and more particularly a director. And then I'm going to outline some of the most likely claims that a director faces that we see day to day. Then Jenny's going to talk to you about some of the trends that we're seeing at the moment, because we're handling D&O claims quite frequently. And then she's going to finish up with some top tips for those of you who are acting as directors or managers at the present time. So who is a director? This slide outlines the various different types. And I think at the outset I would just say, as many of you probably know, a director is an officer of the company who's been appointed by the shareholders to essentially manage the company. And that's everything from making sure that the accounts are filed with Companies House on time to making sure that the company is in compliance with FCA regulations. So pretty broad spectrum there. I think the important thing to remember is just because you're not called a director on your business card does not mean that you may not end up being classed as a director if you're ever sued. So the top type there, which is the de jure director, is the most common, which is a formal appointment, and you'd be registered with Companies House. But the next two, there is no formal appointment necessarily. You may well just be acting as a director and doing the same kind of things that a director would do. Or alternatively, the board may be basically following your instructions. So that's the de facto and shadow directors, respectively. So it is just important to bear in mind that you have to think about what you're actually doing and whether or not you would actually be viewed as a director in the long run if something goes wrong. And the other two definitions we've included are execs and non-execs there. Many of you will be familiar with that. So most company boards will be made up of a mix of the two. An executive is normally an employee, and they will essentially be doing the day-to-day management of the company normally. And you may also have some non-execs, so they're more often people who don't turn up 5 days a week, maybe 2, 3, with specialist skill sets, specialist areas of expertise that they can bring to the management of the company. Moving on to your duties. They originated in the common law and equitable principles of fairness, but luckily for all of us, they've been codified into the Companies Act 2006. Now, that's a fairly lengthy document, but as Jenny was saying before we started, there are some kind of key principles and terms in it that you should be familiar with if you're acting as a director or handling D&O claims. The list is not exhaustive within the Act, but the key ones are found starting at section 171 there. And it's also important to bear in mind, firstly, that you cannot contract out of them or waive your duty to act in accordance with those duties, and they are generally owed to the company, not to the shareholders. So section 171, you must act in accordance with the company's constitution. Essentially that means, as you all know, companies generally have a memorandum and articles of association, and that will set out what the company can do, the areas of business they can be involved in, the kind of duties that directors have, and that's just saying that you have to act in accordance with those documents at all times. 172 is a popular one that gets a lot of commentary and appears in quite a lot of the cases. So that says that you have to promote the success of the company for the benefit of its members. So at all times you need to be acting in a way that you believe is in the best interests of the company. And you might think, well, something that I think is in the best interest of the company might not be the same as the director who sits beside me. How am I supposed to comply with those obligations? There are some guiding principles within the Act. So, for example, you should bear in mind the interests of your employees. You should bear in mind the potential effect on the community and the environment of things that you're doing. So there are some principles in there to help you, but as a general rule of thumb, I would say you should be looking to improve the long-term value and growth of the company. So promoting the success of the company and then exercising independent judgment. That's as easy as it sounds. Essentially, you should be, with your director's hat on, acting in the best interests of the company independently, so without being influenced by outside third parties. So, like all professionals, you will be obliged to act in accordance with a certain standard. 174 sets it out for you there, so you must exercise reasonable care, skill and diligence. So what does that mean? Basically, what would a reasonably diligent person who's also carrying out that function be doing and be expected to do? So that's an objective standard, but it doesn't stop there. If you happen to be a director, for example, a non-exec with a particular expertise in a particular field, the court will bear that in mind when they're looking at whether you've complied with your duties and responsibilities. So 175 to 177 all have a kind of running theme and centre around your obligation to avoid being conflicted in what you're doing as a director and not to be personally benefiting from what you're doing. So you're obliged to avoid conflicts of interest at the outset. So for some of you, if you were, for example, a shareholder in the insurer that was the capacity provider for the managing agent, you have a potential conflict if there is a new deal that comes across your path that would benefit you more as an insurer. So you've got to think about that at all points in time. And if you have a personal interest under 177, you should declare it to the board. It is possible for the board to ratify a conflict in advance or afterwards, but the most important thing is that you make it clear that there is a potential for conflict at the outset. So, what are the potential claims that you might face? We've set out some of the key ones that we see most often when we're handling D&O claims. They fall into two camps, so it'll either be a claim that's brought by or on behalf of the company, or it will be a claim brought by a third party. So going through the first tranche, which is claims by or on behalf of the company, you can see claims by the board themselves. So quite often if a director has resigned or has disappeared and it turns out he's done something that was negligent, the ongoing directors or the new board of directors might pursue him under the company's legislation. We see quite a lot of claims by liquidators. So if the company has become insolvent and they are obliged to try and claw back some assets, they will often pursue the former directors for things like wrongful and fraudulent trading under the Insolvency Act. So there they'll be saying, you either knew or you should have known that the company was on the cusp of or actually insolvent, and you should have put it into administration earlier. And the consequence of you not doing so is that the company has suffered more significant loss. So that's quite a common claim. One of the other ones we put there is a derivative action. So I don't know if you've seen some of that in the press or they've come across your path, but that's where, because the duty is owed to the company, but the shareholder may be losing out, they will bring an action on behalf of the company to try and recoup the losses for breach of duty. But the important thing to remember there is that they have to seek the court's permission to do that. So they will have to go along and say, this is in the best interest of the company that this action is brought. We are all thinking about the best interest of the company and we believe that this director has breached his duties. And then you have the alternative, which is claims by third parties. So there's quite a long list there. Clients, investors, creditors, employees and regulators. I think the ones that I've seen most often have been employees and regulators, and I think we've all know that there's a kind of increased regulatory interest in everything at the minute. So employees will be kind of crossing over with what Matt said, harassment, unfair dismissal, constructive dismissal. That kind of thing is more normally covered by your employer's liability policy than your D&O policy. Regulatory interest, there's all kinds of possibilities. So the FCA could suggest that you, as a manager, have not acted in accordance with their conduct and principles of business. You may be pursued by the Secretary of State for disqualification. So if they think you've breached your duties significantly, they could say that they want you to be disqualified for up to 15 years from acting as a director. You could have health and safety breaches. So there's a wide variety of potential there. The SFO, never-ending list of people who could go after you. And just one further point. It is possible for the court to basically excuse your breach of duty. So you talked about the standard that you're under. If you are pursued in litigation, your defence team could say, the reality is that Joe Bloggs was acting, in his view, in the best interests of the company at all times, and bearing in mind all of the factors of this case, we want you to excuse the breach. So there is a possibility of that. And just finally, potential remedies, not unexpected damages or compensation. And if the claim is brought on behalf of the company, for example, the derivative action, the damages will go back into the company. So it will then be up to the board to decide if they want to give the individual shareholders a dividend. So you could be asked also to account for profits, restore company profits, or if you had a conflict of interest situation, the court could order that the contract in which you had the personal interest was rescinded. I think there's also an opportunity for injunctions. So if you think a director is going to breach their duty, you can seek an injunction from the court in advance to try and prevent that. So I'll now let Jenny take over on claims trends.
Last 10 minutes, so don't worry, you're in the home straight. Can I just ask, how many of you actually handle D&O claims yourselves, or are you here because you're interested, because you're senior managers, etc., and are thinking about your own position? Okay. Well, I'll try and focus then on the general rather than what we're seeing generally across the D&O market. What I thought I'd try and do in these last few slides is just give you a flavour of the new kind of wave of claims that we're seeing. So something a little bit different than the typical claims that Alex has just been referring to. Cyber, of course, is the sort of the buzz, the trendy word that the market's been looking at for some time. And as with most claims, we generally look to the States to see what's going to then follow here. There have been a number of actions in the States where directors have been pursued, where there have been data breaches and customers' information has been released. One of the biggest claims of late is the US retail giant Target, where 70 million customers had their personal data revealed and stolen. And what happened there was there were some shareholder derivative actions filed. And it being the States, they sued not only Target, but a number of the D&Os as well. And what they were saying was that you failed to take reasonable steps to maintain the customer's personal and financial information. You didn't have the right internal controls. You then, when the breach happened, you failed to give us the correct information, and you didn't ensure that the breach was dealt with in the appropriate fashion. And since then, we've heard of lots of others who have had breaches. And I think for insureds, it's a real difficult question. Do they come clean and tell everybody that their information is out there, or do they keep quiet? And some of them you might have heard, oh yes, we had a breach in 2012, and you're only just finding out about it in 2016. In the Target case, interestingly, they didn't succeed against the directors for various technical reasons, but it has made everybody think about it, and it has made the various directors a little bit more concerned about what they need to do. So really, if you are a director or you are a senior manager, it's no good now saying, I'm not really techie, I've just turned it off and on again, or it's all in the cloud, or I don't really understand it. If you are in a senior position, there is now an obligation on you to really have in place an effective control for all of your IT systems. So you need to understand what happens. You need to have emergency measures in place. You need to know what you're going to do in the event of a breach, and that's becoming more and more important. I mentioned InsurTech there. As we're moving forward, I think now younger people buy their insurance when they go on holiday via their app on the way to the airport. I know you can now get pay-as-you-go insurance for different kinds of risks. Things are very much moving forward. And for D&Os, we need to think about how they're making sure that the controls that we would have generally in place are going to keep pace with technology. So this is definitely an area where, in the future, if you haven't got up to speed, if you haven't made sure that the right financial promotion information is in there, if you haven't made sure that the apps deal with everything, that they've clicked through to the right space and we've got all of the information about them, you're going to run into problems when risks abound. So InsurTech is something that we need to think about. Going forward, just a couple of things on the horizon. We've got the EU data protection regulation coming in. It's already in place in the senses that it's passed, but it's not actually effective yet in this country until 2018. But that is where anybody is processing data from any EU citizen. So even if we do have Brexit, even if we're no longer part of the EU, if we're going to be holding as an insurer anybody's information who is within the EU, we are still obliged to comply with these standards. And that's something that, if you haven't already got good systems in place, is going to be something that will be the subject of claims when information isn't handled in the way it should be. And just to let you know, handling data just means holding it. You don't even have to do anything with it. So somebody might give you information that actually you didn't even want. If you hold it, you're still processing it. So it's quite strict. And we've also got the new Insurance Distribution Directive coming in 2018. That's something that the FCA is consulting about at this time, which I think is something would probably be very interesting for you as MGAs when you're processing information and working out how to place the risks. Again, it's something that is moving on from the Insurance Mediation Directive. It's all to do with competition between the different firms, but you are going to have to look at that and make sure that you're compliant. So there's all sorts of stuff out there which I think as senior managers and directors you've got to be aware of. It's quite difficult to give you a checklist of everything that you need to think about because it changes all the time. So I think continuing education and thinking about what might be out there, coming to things like this is very helpful to know what kind of things might be on the horizon. The Bribery Act is just coming into its own now. We all know that there were a couple of brokers who got into trouble. I think one of them just before the Act came into place because they weren't in control of different agents abroad who are getting the new business for them. The SFO is kind of just hitting its stride now in terms of the Bribery Act. It's still not intended to stop the beer after work or the lunch or the rugby day, thankfully for the insurance market. But it is still there and it is still a tool which is going to be used more and more going forward. So if you're involved in any sort of bribery, even if you're not the person who's doing the bribery yourself, you have to take care because there is a failure to prevent bribery. And this kind of failure to prevent is something that the regulators are really looking at in all different kinds of economic contexts. So for things like Tesco's and big accountancy frauds, if stuff is going on and you don't do enough to prevent that kind of behaviour, it's something as a senior manager that you might be called to account over. Insider dealing, not something you might think as an MGA that you have to think about, but mergers and acquisitions are happening all the time. We're seeing lots of consolidation, different insurers, different brokers, all across the industry, and there is still potential for that kind of information to be leaked to those that it shouldn't be. And I mentioned there that the penalty can be quite severe. It's up to sort of 10 years for insider dealing and for certain of the bribery offences. So it can have a personal effect on you if you are the person with whom the buck eventually rests. Regulatory action is something that's been on the agenda for some time. We had, obviously, the financial crisis of 2007, 2008. A lot of this stuff about holding individuals to account is sort of tracking back to Sir Fred Goodwin and the collapse of RBS, and a lot of it has its real origins in the banking world, because there was a real feel that when things went wrong, no individual really was held to account. And historically, what the regulators find is that they can't find the senior individual responsible because the CEO, for example, delegated parts of his responsibilities. The CEO can't do everything. He has to find individuals who he thinks are appropriate and give them responsibilities. And that's what the new senior management regime is all about. Specifically for insurance, we've got the senior insurance managers regime. It's already in place, so hopefully it's something that you already know about if you are someone who is regulated. What it's trying to do is put in place prior agreement about what the scope of an individual's responsibility is. So you have these maps which set out each individual, what they're expected to do and why, so that when something goes wrong, they point back to these maps and say, well, actually, this happened on your watch. This is your fault. So it's something that you have to think quite carefully about. And as a business, you have to make sure that your compliance people are looking at the various different maps and that the right individuals are being held to account for the right responsibilities. We don't have a certification regime for other members of staff as they do in the banking world, so they have a fit and proper regime. But what we have got now, in line with the banks, is a whistleblowing regime which came in September 2016. And this links quite well, actually, with the employment aspect. So now what you need to have is a whistleblowing champion, someone that any employee can go to in your business and say, look, this is going on. I don't think it's right. I want someone to take it seriously. There is then an obligation on the business to investigate properly, to produce a report, to document matters, and also to produce an annual report to the regulator saying these are the kinds of issues that we've had. And it's a bit like sending the wrong email to the wrong firm. You need to keep a register of it. And if there's no whistleblowing going on, you can imagine the regulator is going to start looking at those different organisations where that's not happening. We've also got the Lloyd's rules and the MS11 conduct standards, which I had a look at. They sit nicely together with the FCA obligations, but if you are an MGA, that's a very good place to start in terms of what you should be saying, particularly for the consumer policies which are going out there. It's the same kind of obligation as the FCA would impose, so things like treating customers fairly, wordings being fair, clear and not misleading. And if you can start as a business complying with those kinds of requirements, then hopefully you should also be able to convince the regulator that you're treating compliance seriously. But this general shift to regulatory matters and holding individuals accountable is something that's going to continue. So it's not something that's just going to be a flash in the pan. For the last slide, I thought I would just try and give you some practical tips. As Matthew was saying, it's not really rocket science, but it's the same issues that we come up time and time again when you are called in when something has gone wrong. So far as a senior manager or a director can, it's very important that you do understand what is expected of you in that role. A lot of people get promoted, you know, they obviously are looking for the remuneration, but they don't often see the downsides to some of this. And certainly in the financial institutions sphere, we've seen quite a lot of quite senior people saying, I don't like this new regime, actually I'd rather not do it. So it is very, very onerous, and you do have to be careful about what you're taking on. So you do need to understand what it is you're obliged to do. Make very, very careful notes of things which are said in board meetings, so your board minutes are very important. Not just those, also your emails. Make sure that they're backed up, make sure that there is a server which can never be destroyed. It's very important to track the document trail as to why decisions were taken. If you can show that your decision was reasonable, even if somebody else might not have taken that decision, that doesn't necessarily matter, as long as you can show that you did consider things. Alex has mentioned conflicts of interest. Very important, I think, for an MGA when you've got the conflicting expectations, shall we say, of capacity providers. You know, you need to be clear what you're writing. You've got your delegated authorities, you've got the contractual side of things, but you have to be clear that what you're doing is in the interests of the MGA at the time, regardless of what other obligations you might have to a wider group. Managing cyber risk, very important. Managing your data. Breaches are happening all the time, we are told, and it's very easy, I think, if someone sets their mind to it, to access your data. Do engage with your compliance departments. I'm not sure if many of you might outsource your compliance functions. If you do, please do listen to what they tell you. I was up with a director at the FCA very recently who had this lovely compliance report and then had just put it in a drawer and nothing had happened with it. So he kind of did the first stage and he knew what he needed to do, but then in the follow-through it didn't quite work. And then, of course, the FCA delighted in producing that and hitting him over the head with it as to what he ought to have done. Keep an open dialogue with your regulators. Supervision can be your friend before enforcement get involved, so do have full and frank conversations with them. Do make it very clear what you're going to do in response to any action plans that they give you, and also do take a very careful note of the guidance that they give you, because that can help if later on someone finds that you may have fallen short. We haven't got time today to talk about D&O cover, but do make sure you know what it actually is providing cover for. Normally, if you're a director, it'll be the side A cover where you've got no deductible, and then you've got the side B where the company can indemnify you. If you've also got side C, where, for example, a securities class action claim in the US might take out all of your cover, you might want to think about your own side A DIC on top, because a lot of this stuff may take up a lot of your D&O cover. Even if it's a completely fanciful claim, it's eaten up in the defence cost. So, you know, make sure that it's adequate and you understand what is going to be there. The D&O cover will provide generally EPL cover as well. You usually get the blended wordings, and often you can get PI cover as well. You need to look at your limits and see whether they're combined limits and otherwise. So that's a bit of a whistle-stop tour around D&O. If anyone has specific questions, either for myself, Alex, or for Matthew, then please let us know. D&O insurance can be a bit of a minefield, but with some simple steps you can help yourselves to at least put together a decent defence if someone does come after you. That's it. Thank you very much. Thank you for listening. Did anyone have any questions?
One for Matthew. Talking about people being off short time, etc. You said that what is reasonable in relation to absence. Can you just fill in a little bit, irrespective of what the contract of employment might say, but what would you view as being unreasonable if somebody keeps taking time off?
It really is a difficult question to answer because it will depend on the particular size and resources of the employer. So the standards by which a large employer with thousands of employees will be expected to meet is going to be different from a small employer with only a dozen employees. So as a general rule, the smaller the employer, the less absence they would reasonably be expected to tolerate. But typically you're not going to be acting fairly by dismissing for a few days absence. But where you've got a clear pattern of days off here and there throughout the year and it's getting into double digits, then you may well be in a position where you can start to take warnings and ultimately dismiss an employee if their attendance doesn't approve. I'm sorry that's a bit of a how long is a piece of string type answer, but it really will depend on the particular employer. If the employer can say, well, this is giving me these specific problems and that's why I cannot accommodate that particular level of absence, then it will be reasonable.
Thank you. Ladies and gentlemen, any questions from the floor?
Yeah, I was just interested to know about, so most contracts these days have warranties in, which is about transfer of business, which are always difficult to enforce because you've then got the whole issue about whether people can actually transfer a job. So where's the sort of current state of play with that?
In terms of commercial contracts,
yeah.
You're talking about, yeah.
Yeah.
So, I mean, there's a bit of legislation which I didn't talk about in the presentation called TUPE, or the Transfer of Undertakings Protection of Employment Regulations 2006, to give it its fuller title, and that's the law which effectively deals with the situation where an identifiable business or part of a business transfers from one entity to another. And as long as you can show that the employees are assigned to that particular bit of the business that's going, then they would automatically transfer their employment across to the new operator of the business. And as you can imagine, it's a lawyer's minefield to work out whether that particular employee is actually assigned to that part of the business, and if so, to what extent and when they transfer and so on. But that law has been in place in its different guises since sort of the early 80s. It's a good example of one of the European laws which has filtered down into the UK. But the basic principle has remained pretty much the same and still is. What you often see in the commercial contracts, as you're alluding to, is something where the commercial parties will deal with what happens in that situation, because you cannot contract, the commercial parties cannot contract out of TUPE. So the commercial parties might say, well, in our view, TUPE doesn't apply, or we don't want it to apply, but that doesn't stop the employees involved saying it does or doesn't, depending on what their stance is. But what you do often see is the commercial parties coming to some sort of agreement between them as to who will pick up the tab. So if TUPE applies, the incoming employer might get the benefit of some sort of payment, some sort of indemnity from the outgoing employer for anything that happened on the old employer's watch. And it's ultimately a commercial point to be negotiated in any transaction. But it's still there, I'm afraid. And just sorry, one thing I omitted to mention about the short-term absence point. It's a good example of why it's a real benefit to have that policy in place that sets out the level of attendance that will or will not be acceptable, so that everyone is clear from the outset of employment.
Thank you, Andy. Okay, let's call this session to a close, and would you please join me in thanking our panel.